Yeah, good morning, ladies and gentlemen. I welcome you to the second day of our conference. The organization of this conference started already 2 years ago. When Burkhard, we know us since the time in Munich, as we were young assistants. Burkhard came to visit us in Saarland, and we have the idea of this conference. I'm very happy that this meeting can take place now, and thank you, Burkhard, very, very much for your commitment by the perfect organization of the conference. I hope that the Max Planck Institute of Luxembourg and the Faculty of Law of the Saarland University will be able to continue on a cooperation.
We are back.
The subject of this first panel is, as you know, transparency and the appointment of judges. I cordially welcome the speaker, my colleague at the Faculty of Law of Saarland University, Thomas Giegerich, as well as the discussant Siofra O'Leary, judge at the European Court of Human Rights, and Professor Alberto Alemanno of the HEC Paris and New York University School of Law, who are going to start the discussion. Thomas, I pass over to you.
Thank you very much. Can you hear me all? Does the mic work? Great. Good morning, ladies and gentlemen, and thank you for giving me the opportunity of sharing some thoughts on the selection of Constitutional Court judges with you this morning. Constitutional courts exercise constitutional jurisdiction, either alongside their other jurisdiction, such as the Court of Justice of the EU and the US Supreme Court, or as specialized constitutional courts such as the European Court of Human Rights and the German Federal Constitutional Court. They enforce the constitutional constraints to which political power is subject in any system based on the rule of law. Their exercise of political power in judicial forms gives rise to the counter-majoritarian difficulty. At a time when constitutional courts on the national, international, and supranational level have come under attack from populists and autocrats, it is important to sustain public confidence in their indispensability as guardians against arbitrary government. In a democratic system, the rule of law cannot be maintained without public confidence in the institutional and operational legitimacy of constitutional courts. With regard to the process of selecting the judges, that legitimacy derives from a synthesis of transparency and effectiveness. The institutional legitimacy of constitutional courts pertains to their input legitimacy as a branch of the government by the people. It also pertains to their social legitimacy, that is, their popular acceptance as a branch of the government of the people. Both the input and social legitimacy of constitutional courts depend primarily on their democratic legitimacy, one important element being the transparency of the judge selection process and the social representativeness of the bench. In case of federal or supranational courts, the federal or supranational representativeness is another important additional factor. The operational legitimacy of constitutional courts is linked to their output legitimacy as a branch of the government for the people. It depends on these courts' effectiveness, that is, their ability properly to dispense justice in high quality and good time through persuasive opinions which definitely settle the constitutional issues. The most important prerequisite is the personal and professional quality of the judges. Their personal quality consists in their unquestionable independence and impartiality. Their professional quality is characterized by their excellent knowledge of the law and ability to function as a constitutional court judge. From an operational legitimacy perspective, the main concern with regard to the judge selection process is not its transparency, but its ability to produce a high-quality bench that ensures the effective functioning of the Constitutional Court. This may require certain trade-offs with regard to the transparency of the process. The Constitutional Court's exercise of political power in judicial forms presupposes that they have a considerable degree of democratic legitimacy of their own. Otherwise, they cannot overcome the counter-majoritarian difficulty. This requires parliamentary control of judicial appointments, which also tends to increase the transparency of the process. Since constitutional courts are courts, their democratic legitimacy must accommodate the three fundamental conditions of effective fulfillment of their judicial tasks, namely independence, impartiality, and professionalism. Thus, the design of the appointment process must ensure the selection of judges whose credibility in these respects is beyond doubt. The transparency of that process may be limited inasmuch as excessive transparency deters suitable candidates for what is primarily a judicial and not a political office. As the temptation is great for the political majority to pack a constitutional court with partisan judges, effective legal safeguards need to be established against such threats to independence and impartiality. This requires the constitutionalization of the important rules, qualified majorities for the parliamentary election of judges, and perhaps judicial review to increase transparency of the reasons for the appointment of a certain judge and enable annulment of arbitrary appointments. Their independence makes it impossible to hold constitutional court judges directly democratically accountable. They are only indirectly accountable in the court of public opinion, and that accountability is enhanced if they are permitted to write separate opinions. These also increase the transparency of the adjudication process, thus promoting public confidence in the Constitutional Court. Since the transparency of the judge selection process is but one important element ensuring the legitimacy of constitutional courts, it needs to be contextualized. The decisive contextual question thus is, does the selection process demonstrably reconcile conflicting popular demands for transparency and effectiveness, social and federal or supranational representativeness, in a way that promotes public confidence in the Constitutional Court? Let's start with a brief look at the US Supreme Court, which I'll call SCOTUS henceforth. Few constitutional provisions regulate the appointment of SCOTUS justices, leaving broad discretion to congressional legislation and volatile political practice. The justices enjoy life tenure. This gives appointing authorities the power to influence the court's case law for decades and is the reason why the appointment of justices can give rise to major political battles. The individual justices are constantly present as authors of majority opinions and separate opinions. The adjudication process is therefore as transparent as possible. The appointment process requires the cooperation of the President and the Senate that both enjoy a high degree of democratic legitimacy which they pass on to the justices. Moreover, the involvement of the Senate ensures their federal legitimacy. There is an important but informal quality control by the American Bar Association. While the president alone determines the amount of transparency of the nomination process, the confirmation process in the Senate is transparent. In practice, each nominee is subject to a long and intense public confirmation hearing in the Senate Judiciary Committee. This hearing probes the nominee's character, knowledge, and judicial philosophy. It can get aggressive if political opponents try to destroy a certain nominee in front of the cameras. Senate confirmation requires no more than a simple majority. Thus, if the President and the Senate majority are politically close, they can staff the Supreme Court with their ideological partisans. The filibuster had temporarily been used to raise the necessary majority to 60%, but that practice was abandoned last year with the confirmation of Neil Gorsuch. Turning to the German Federal Constitutional Court, the German Basic Law contains few provisions on the appointment of judges of the Federal Constitutional Court, setting forth only that half of them are to be elected by Parliament, the Federal Diet, and the other half by the Federal Council, the representation of the constituent states. The Federal Constitutional Court Act stipulates one single 12-year term of office and requires a 2/3 majority in the Federal Diet or the Federal Council. As a result, the judges of the FCC enjoy a solid democratic as well as federal legitimacy. The Federal Diet elects half the judges upon proposal of a 12-member election committee. The committee procedure is confidential. Until 2015, that committee actually carried out the election for the plenary. Even after the retransfer of the electoral power to the plenary in 2015, the election committee remains important because the candidates it proposes are always elected by the plenary. The FCC held that the delegation of electoral power by the plenary to the committee until 2015 was constitutional. Although that delegation conflicted with the equality of deputies because it excluded so many of them from the election, it was supported by confidentiality concerns in the interest of the FCC's reputation and proper functioning. In other words, the lack of transparency of the committee process amounted to a constitutional value which outweighed the constitutional value of equality of deputies. In view of the 2/3 majority requirement, the two major political parties in Germany, the Christian Democrats and the Social Democrats, have so far jointly controlled the election process. According to an unwritten but generally known political agreement between them, they both have the right to nominate 4 of the 8 judges in each of the 2 chambers of the FCC. While this modus vivendi as such is transparent, its application in concrete cases remains completely obscure. This modus vivendi is an instance of political patronage which violates basic constitutional principles such as the prohibition of discrimination based on political opinion and the command that every German shall be equally eligible for any public office according to her aptitude, qualifications, and professional achievements. In a representative democracy, however, it is impossible to eliminate the influence of political parties on political appointments. Since the Christian Democrats and the Social Democrats lost their 2/3 majority in the Federal Diet in the elections of last September, the fate of the modus vivendi is uncertain. This procedure for selecting FCC judges is completely non-transparent. Yet demands to make it more transparent by a public hearing of candidates have not been fulfilled because of fears that this would lead to an excessive politicization like in the United States, and discourage well-qualified candidates. But I believe that a public hearing by the election committee of a small number of shortlisted candidates should be introduced, and trust that it would be conducted in a civilized way. The current non-transparent procedure has so far ensured the selection of highly qualified judges with a distinct sense of judicial duty beyond political partisanship. It has produced a well-balanced bench whose decisions have been both well-reasoned and politically sound. Public confidence in the FCC has constantly been high in Germany. The selection process having thus been effective, it should, in my opinion, nonetheless be made more transparent. Now, around the corner to the Court of Justice of the European Union. All the relevant rules on the appointment of the judges and advocates general are laid down in the treaties. The selection procedure is completely in the hands of the member states, largely non-transparent and anachronistic. The judges and advocates general are appointed by common accord of the national governments for a term of 6 years. Reappointments are permitted. In practice, each government proposes a candidate who is then confirmed by all the others. The Treaty of Lisbon introduced an expert panel in order to rationalize and objectify the appointment process, ensure the personal and professional quality of candidates, and eliminate arbitrary considerations such as partisanship, closeness to a government, or national interests. The panel reviews the suitability of candidates proposed by the governments in a confidential procedure that avoids transparency in order to protect personality rights. This lack of transparency is partly compensated by the panel's period activity reports. The opinion of the panel is not legally binding, but a disqualified candidate will in practice not be appointed. Since 2009, German candidates are nominated by the federal government by agreement with the Committee for the Election of Judges. That committee consists of the Ministers of Justice of the 16 Länder, the constituent states of Germany, and 16 members elected by the federal Diet. While the national legitimation basis of the German candidates has thereby been broadened considerably, the selection process remains non-transparent because the proceedings in the committee are confidential. The appointment procedure of the judges and advocates general raises an issue with regard to their independence. Their term of office is short and renewable, and their reappointment depends on the proposal by their government. That situation, quote, may well consciously or otherwise impact his or her conduct, or, no less importantly, give the appearance of lack of independence, unquote. That problem should be fixed by introducing one longer non-renewable term. With that amendment, the judges should also be permitted to write separate opinions in order to increase the transparency of the adjudication process and promote public confidence in the Court of Justice. The over-federalized appointment procedure should be replaced by the following parliamentary procedure. The member states propose candidates who, after having been approved by the expert panel and obtained the consent of the qualified majority of the Council, are elected by the European Parliament. Before the vote in the plenary, a public hearing of the candidates is conducted by a parliamentary committee. This can be done, I believe, without constraining critical questions or jeopardizing judicial impartiality. Now I take you on the train to Strasbourg. The judges of the European Court of Human Rights now serve for one non-renewable 9-year term. The criteria for office are set forth in the Convention. The selection process has been characterized as a quote, unique mix of meritocracy and democracy, unquote. The judges are elected by the Parliamentary Assembly from a list of 3 candidates nominated by the respective state party. Election results are publicly announced by the President of the Assembly. However, quote, virtually nothing is known publicly about the internal mechanics of the election process within PACE, unquote. Problems with the quality of candidates from various states have prompted interventions by both PACE and the Committee of Ministers of the Council of Europe. In 2010, the Committee of Ministers set up an advisory panel of experts that is modelled on the panel established under Article 255 TFEU. PACE has insisted that all 3 candidates included in a member state's list must meet the criteria for office, giving PACE a real choice. Every list should include candidates of both genders. The national selection procedures need to be fair, transparent and consistent, and be based on public and open calls for candidatures. If the list submitted by a state does not meet these standards, PACE will reject it. The PACE Committee on the Election of Judges examines the candidates, conducts personal interviews and makes recommendations to PACE, including a ranking of the 3 candidates. However, it meets in camera. The confidentiality of the committee procedure is, I believe, wrongly considered as essential for 2 reasons. Firstly, protecting the personal data and personality rights of the candidates. Secondly, ensuring the committee's effective functioning, including the possibility of posing critical questions and making unfavorable assessments of candidates. All in all, the federal and democratic legitimacy of the Strasbourg judges rests on a sound basis. The European part of the selection process is more transparent than the national part, but the latter's transparency has been considerably improved. European demands in this regard were not focused on the transparency of the national process as such, but on its effectiveness in identifying suitable candidates. Placing transparency in the context of legitimacy, effectiveness, quality and independence amounts to the squaring of the circle. In the judge selection process, democracy, including transparency, and meritocracy have to be reconciled as well as possible. Because of their political power, Constitutional Court judges need democratic legitimacy conveyed by a parliamentary appointment process, which also tends to enhance transparency. There is adequate parliamentary input in the selection of the judges of the FCC, the European Court of Human Rights, and SCOTUS, but not the Luxembourg Court. Concerning the transparency of the selection process, the US model is the most open one, followed by the Strasbourg model. The FCC comes last, and the Luxembourg Court is completely out of the game. While the democratic legitimacy of constitutional courts requires transparency of the judge selection process, the first priority is to recruit candidates of excellent personal and professional quality. That process's effectiveness therefore depends on whether it produces judges who fulfill these standards. While this has always been the case in the United States and Germany, there were problems with regard to both the Luxembourg and the Strasbourg Court. The EU and the Council of Europe have therefore introduced advisory expert panels for screening candidates. This has had a positive impact on the national candidate selection processes, both regarding the quality of nominees and transparency. But the panel procedures, both in Luxembourg and Strasbourg, should themselves be made more transparent to ensure democratic accountability. While parliamentary involvement tends to increase transparency, there is no automatism, as the examples of the FCC and to a lesser extent the Strasbourg Court demonstrate. The confidentiality of the selection process is based on the false assumption that transparency would impede the recruitment of high-quality candidates. Looking at the Strasbourg Court, however, one notices that the argument cuts both ways. In Strasbourg, the transparency was increased precisely in order to compel governments to nominate well-qualified candidates. The Strasbourg appointment process constitutes a compromise between transparency and effectiveness, but still unnecessarily underrates the former. The important rules on the constitutional courts, including those on judge selection, should be entrenched in the Constitution, making them not only transparent, but also preventing the political majority from undermining the effectiveness of these courts. The Luxembourg Court, and to a lesser extent the Strasbourg Court, meet this standard, but not the FCC and even less SCOTUS. Requiring a qualified parliamentary majority for the election of judges is an important corrective against the packing of constitutional courts with political partisans. That standard is met with regard to the FCC and the Luxembourg Court, but not the Strasbourg Court and SCOTUS. Concerning the Strasbourg Court, however, the international composition of PACE, that is also limited to choosing from lists of candidates proposed by states, attenuates the risk of a politically one-sided composition of the court. The difficulty of mustering supermajorities can intolerably delay the filling of vacancies and thereby reduce the effectiveness of the constitutional courts. An effective subsidiary mechanism should therefore be available. However, none exists in any of the 4 jurisdictions. Neither short renewable terms of office such as those in Luxembourg, nor lifetime appointments such as those in the US are ideal. The Luxembourg solution conflicts with judicial independence, whereas the Washington solution makes changes too infrequent, progressively dilutes the democratic legitimacy of individual judges over time, and provokes excessive politicization of the appointment process. Both the Strasbourg Court and the FCC provide examples for the obvious compromise reconciling democratic legitimacy and independence, namely single, non-renewable terms of office, short enough to sustain the judge's democratic mandate, but long enough to ensure continuity in the court's operation. Separate opinions should be permitted and frequently written in order to increase the transparency of the adjudication process and enhance the indirect public accountability of the respective court. Only the Luxembourg Court fails to meet this standard. The possibility of judicial review of appointment is doubtful in all 4 jurisdictions. In summary, this is my answer to the contextual question. All 4 jurisdictions demonstrably reconcile the conflicting popular demands differently, but more or less well. Need for improvement is discernible in all of them with regard to different aspects of the judge selection procedure. The 3 European courts in the quartet should at any rate hazard more transparency. Thank you very much.
Thank you very much, Thomas, for your informative speech, very informative speech. In fact, every system of appointment of judges had advantages and disadvantages, is the result of specific historical, political, economic factors. But connected here with is another very important question, Und zwar, oder of what purpose should be reached. Purpose should be reached when you decide for whatever system. And from the other in questions, from which tradition one is coming, juridical, cultural, economic tradition. But we have not long time, said Burkhardt. Judge Ollier, would you please open the discussion?
Thank you very much. Can everybody hear me? Because I'm unused to this very modern mouthpiece that I have. In fact, I was due to speak after Professor Alemanno, but I will precede him. First of all, many thanks to Professor Giegerich. He's given us what I would call a report card on 4 courts: the US Supreme Court, the German Federal Constitutional Court, the Luxembourg Court just a few kilometers down the road, and my own court, the Court of Human Rights in Strasbourg. And I should perhaps say that until a few weeks ago, the intention had been to have a Luxembourg judge sitting on this panel. I was asked to step in at a late stage. So I'm wondering simply, did the Luxembourg judge step down because he thought the report card was going to be too negative? Certainly from the perspective of a Strasbourg judge, it came as some relief to find that the Strasbourg report card was relatively positive. One could say a B+ or an A-, but with room to improve. And at one stage during the course of his presentation, I wondered whether he was going to turn around and say Exhibit A and point in my direction. But leaving a little bit of humor aside, Professor Giegerich has just explained, and of course I'm best placed to speak to you about a selection procedure which I experienced in my own flesh, a selection procedure which involves open advertisement at national level, a national selection procedure, an advisory panel composed of judges, an interview by a parliamentary select committee which is composed of politicians, but those who have had legal experience. Some of them have been judges themselves, and subsequently an election by a parliamentary assembly. I think it's fair to say that when a judge arrives in Strasbourg, having gone through that procedure, we regarded, most of us, as an obstacle course, and one that we survived. And it's quite often that you'll hear judges in their first year comparing war stories, because it's quite an obstacle course. And I think it's important when we come to discussing questions relating to, as I'm sure Alberto will encourage us to do, this balance between transparency on the one hand and reasons given, for example, by the 255 panel not to disclose favorable or unfavorable opinions, the idea that you should protect someone's privacy and data protection rights. As someone involved in the process, I can understand that the balance is important and that the individual right does have some weight in the balance to be affected. Now, I didn't come here with a set speech on purpose because I wanted to listen to the presentation by Professor Giegerich. And partly, I think my role this morning is to enhance the discussion that you are going to have with the panel rather than take up a lot of time. But my first question for you, and you'll see that I'm going to play perhaps the role of devil's advocate here. Let us all accept that transparency is a very, very positive thing and something which is extremely necessary for the reasons eloquently explained by Professor Giegerich. But what's the purpose of transparency? Which, of course, we must remind ourselves, is a principle, to use the language of the Court of Justice in the data protection case Volker and Schecker. Transparency is a principle, a general interest objective. It's not as such a right, and it's certainly not an absolute right, in the same way that privacy or data protection rights are not absolute. And I agree entirely with the speaker that the purpose of transparency in this context is very simple. It's to ensure that you have a high-quality bench which produces authoritative, quality jurisprudence and whose independence and impartiality is absolutely beyond doubt. And working in a court with 47 judges from 47 different Council of Europe member states, the words independence and impartiality are very frequently discussed. They're absolutely essential. Professor Giegerich has given you two aspects of the Strasbourg system which are very positive in this respect. We have one 9-year term of office, non-renewable now. And second of all, we have the possibility, when we feel the need, to issue separate opinions. This feeds into how the court works internally. But of course, as you know, the questions of independence and impartiality are questions that our court has to deal with all the time in relation to domestic courts and Article 6 in particular, questions which arise at domestic level. And since we've been talking about principles and rights, but we in this room are either academic jurists, practicing lawyers, judges, you will forgive me if I deviate and just have a little bit of a quick look at the jurisprudence on this subject. Case law of the Court of Human Rights is quite developed on the subject. You can find it under Article 6, the question of a tribunal or court established by law. And we see in the case law why we need all of this, why it's important, going back to a Commission decision from 1978, Sand against Austria, where the court said judicial organization in a democratic society must not depend on executive discretion and must be regulated by a law emanating from Parliament. Or indeed, Guruv against Moldova, a case from 2006, where it said established by law covers not only the legal basis for the very existence of a tribunal, but also the composition of the bench in each case. Or more recently, a Grand Chamber decision in a case called Maktuf against Bosnia against Herzegovina, where the court said, however, appointment of judges by the executive or the legislature is permissible provided appointees are free from influence and pressure when carrying out their adjudicatory role. And this, of course, is reflected also in the jurisprudence of the Court of Justice of the European Union. Take, for example, a recent decision of the General Court in FV against the Council of Europe. And note, of course, the case was a case against the Council of Europe, not against the court itself, in which it looked at the notion of le juge légal. And it said judges must be impartial and independent, and the procedures for their nomination must appear so also, or even a recent judgment of the EFTA court, Pascal Nobile. So we see these requirements of independence and impartiality throughout the case law of the Luxembourg court, the Strasbourg court, of course, national courts as well. Unusually, Strasbourg has also been in the position to hand down an advisory opinion. It was, in fact, requested by the Committee of Ministers following a particularly controversial or difficult selection procedure to give an advisory opinion on the way in which the procedure was operating. It was handed down, unanimous decision, in fact, in 2010. And there again, the court emphasized, and this was regarding its own composition, the nomination of its own bench, the absolute need to ensure the authoritative and proper functioning of the court, and therefore the need to interpret the provisions of the Convention and the relevant selection rules to preserve the independence and impartiality of the court and its judges. So I think we can take as a given, as Professor Giegerich has clearly pointed out, why we have transparency as a principle or objective, yet it is not an absolute. There is a balance, there is a trade-off, and I think he very clearly indicated some of the trade-offs. My difficulty, I would say, and this is where I regret actually not being able to listen to Alberto first and then respond, but I know his writings on the subject quite well, is that there's a risk that transparency becomes the end in itself. And I think that if we lose sight of that risk, then all of the focus will become about the process itself, about its beauty. But perhaps there will be too little emphasis on what the process actually produces, which is, in my experience, someone who sits around a table with 46 other judges in a plenary formation, or 16 other judges in a grand chamber formation in some of the most difficult and challenging legal questions which are coming before the European Court of Human Rights now. The purpose is, as he said, to produce a high-quality bench capable of giving authoritative, clear, quality, coherent, consistent rulings. It's not about the external beauty of the process. And if we concentrate excessively on transparency so that it becomes an end in itself, the next question is, where does it end? Because as someone who has been involved as a student and onwards in EU law, and now subsequently the Convention, for, I suppose, 28 or 9 years, what we're looking at now, a selection procedure both in the Council of Europe and the European Union, it's transformative. It's been revolutionized. You have 2 advisory panels, both working very effectively, I would say in most cases, on both levels, giving opinions in order to ensure that that purpose, a high-quality bench which produces the type of judgments that I'm talking about, is actually constituted, and limiting the previously very wide discretion, if not absolute discretion, which had been left to member states when nominating candidates, 3 in the case of Strasbourg, 1 in the case of Luxembourg. Because if you concentrate, as for example, some scholars do, and I think Alberto has written quite a lot on this, you could concentrate on the transparency of the process overall. And then you could start separating parts of that process, concentrating on the transparency of the functioning of the 255 panel. But that will lead you to concentrate then on the transparency of the appointment of the 255 panel. And then we'll have to go back to national level and we'll have to concentrate on the transparency of the national selection procedure. And then the transparency of the nomination of the national selection procedure body. And there is no end. And so I really am not trying to place devil's advocate, but I'm trying to place transparency as a functioning judge, and hopefully one whose report card is fairly positive, in its proper context. It's a very important objective. It should not be forgotten. Great progress has been made. Further progress needs to be made. I would be the last person to suggest that all selection procedures for Strasbourg or anywhere else are unimpeachable and couldn't be improved. But nevertheless, the purpose must be kept in mind, the production of high-quality judges capable of doing the job. And believe me, sitting in a plenary formation with 46 other people, most of whom are not speaking their mother tongue, or even their second strongest language, deliberating subjects which are extremely difficult. You need qualities which I think several academic theses could be written on the subject. So I think transparency is essential, but let's put it in its proper context. The advisory panel for the European Court of Human Rights plays a particular role. It doesn't have the same not binding force, but the same force as the 255 panel, as Professor Giegerich and others have pointed out. But nevertheless, it is an absolutely essential layer in the process, because it is composed of judges who have previously performed the function for whom the people before them are being nominated to perform. They've done it for years. They have experience. A personal regret, a personal opinion, would be that the advisory panel in the Strasbourg process doesn't have actually more weight. As regards to the 255 panel, yes, it is true that their opinions are not published, but what we do have is a series of activity reports which are extremely detailed. No potential candidate, actual candidate, nominating government or member of the council could be in any doubt as to the working methods of that panel. I think they come out quite clearly in the activity reports, and the reports have become more detailed over the years. Now, as lawyers, again, we could diverge to the jurisprudence and we could have a discussion about should they publish those opinions. And I'm sure some of you here would say, yes, they should, and others would possibly argue that no, they shouldn't. The panel itself has referred to privacy rights and data protection considerations in accordance with the relevant regulation on access to information. It's a perfectly tenable position, I think. The reference has been made in one of their reports to the Bavarian Lager jurisprudence of the Court of Justice. And again, as a judge, it's difficult not to deviate and go back to the jurisprudence, because that's what I do every day. When it comes to privacy rights, the Luxembourg court has said quite interesting things, remember, in recent years. Take Volker and Schecker. That was a case about access to information about the recipients of agricultural aid. And if you look at paragraph 79 of the judgment, you'll see that the court says one thing. Striking proper balance between various interests involved made it necessary for the institutions, the EU institutions, before adopting the legislation to ascertain, and I quote, whether publication via a single, freely consultable website in each member state of data by name relating to all the beneficiaries concerned and precise amounts received did not go beyond what was necessary. Another groundbreaking data protection case, Google against Spain. You all know the right to be forgotten. Now, judges don't have a right to be forgotten. They leave their trace on the jurisprudence either collegiately or in separate opinions. But in Google Spain, again, look at the effect of publication in the manner which we now know would take place on a search engine, which, according to the court in Google Spain, is liable to affect significantly the fundamental rights to privacy and to the protection of personal data. And this effect is heightened, and I quote, on account of the important role played by the internet and search engines in modern society. An Irish case called Kelly against UCD, in which a candidate had sought access to information because he wanted to prove that he was the victim of sex discrimination. And there the court said that data protection protected those who had applied for the job from having all of their details given to this particular applicant. Now, here I am playing a little bit devil's advocate, and I'm sure that Alberto will have an absolutely fantastic response for me. The Ombudsman was asked about this in recent years, and she handed down an opinion in which she argued successfully, because the Council changed its practice, that you should have access, that Regulation 1049/2001 does apply to the workings of the 255 panel. She also suggested that the Council should reopen the particular access request that had been made, and which I think went a little bit perhaps farther than her role, she suggested that partial access should be granted. That's for others to comment on that. But she pointed out that those who have actually been appointed should be willing to accept more information being divulged about themselves. And I would totally agree. But a person who's before a selection committee has not actually been appointed yet. And as the 255 panel has indicated, people may be rejected for very legitimate reasons which have nothing to do with their professional competence. In fact, the error may have been made by the National Selection Panel. But they will bear the consequences of that for many years. And I think it is important not to ignore the consequences for an individual of an unfavourable opinion of that nature. In brief, I hope I've been short enough. I hope I've been clear enough. I hope I've lived up to the Strasbourg report card. Transparency is an absolutely essential objective in a modern democratic society, and that objective runs through the case law of the Strasbourg court. But I would argue that it is not the end, it's not the purpose. The purpose is, as explained by Professor Giegerich. We're doing better, more could be done. For the time being, I will listen with great interest to Alberto and hope, if need be, that I have a right to reply.
Thank you very much. Alberto, you have the floor.
Thank you very much. Good morning, everyone. It's a pleasure to be here, to be the last in this panel, to have the possibility to respond to all my panelists. I know what they think about judicial transparency, but I don't know what you think about judicial transparency. I'm very tempted to ask, but you're not my students, and some of you might even be conflicted by actually raising a hand in favor of disclosure or against disclosure. So I will prevent myself from asking such a question. I feel there's an expectation that I should disagree or agree with someone here in the panel. I think I agree with virtually everything that has been said so far, besides a few notes. And I'm going to be focusing probably on those notes in order to make it more interesting. A few caveats. I think that judicial selection at the EU level and at the level of the Council of Europe has improved over time and is certainly scoring better than what is happening at the national level. If we make a step back, the interest I nurture over the years vis-à-vis the issue of judicial transparency belongs to a much broader scholarship that look a little bit at how courts are changing the relationship vis-à-vis the outside world. It looks at how the old assumption according to which courts and members of courts could be insulated from the outside world is no longer tenable. The world is changing very fast and is inevitably affecting the way in which judges do interact one with another, and this will inevitably also affect the process through which those members will become citizens who are also judges. It is against this backdrop that I've been trying to figuring out over the years by playing also a bit of a role of an activist in pushing through the European Ombudsman Office some new thinking in checking how much transparency there should be in judicial selection. By certainly being aware that transparency is a means to a higher end. And the question, therefore, is how much the public should know how an individual, how a citizen who belongs to the many should become one of the few. It is really about an internal cuisine. It is an internal cuisine that my colleagues have described as with very little light, in which the only chefs invited were coming from the member states. And at some point, we just became a bit suspicious. It was around 2010 that we realized that some agents, some members, chefs were not washing their hands. So exactly like we do for restaurants, we thought about introducing some hygiene rules. And those hygiene rules, they basically developed into external observers. Observers who actually have been in the cuisine. And they might know a bit better than anybody else who might be apt for the job. The observers were invited. The cuisine look a bit packed now. We have many more actors involved. There's even an extra layer within the framework of the Council of Europe. But the overall status of the light is not really happy. We don't have much light in that cuisine. And the question is why this might be problematic. Not because we want to turn the light on, but because the only fact that you have observers in that room, that you have more actors involved, is changing deeply the way in which we are selecting those judges and those candidates. There are new power dynamics that exist. There are new way of shaping the process for which at the national level we are selecting those candidates who will be invited to the cuisine for their talk. So there's a much deeper reason why we should ask the question about how much transparency we should ensure to such a process and trying to see whether we should switch that light or not. Let me give you a few examples of what do I mean by transformational effect of the creation of the advisory opinion in the Council of Europe or the Article 255. Today, we cannot say that the quality check has become unified, it has become objectified, this was the original objective, but is significantly shaping the judicial process by affecting the outcome. There is a fact-finding prerogative of both advisory bodies, so there is the possibility to inquire and to collect evidence about those candidates. And there's also a pedagogical mission that has been given to them, clearly. We expect those advisory bodies to shape the way in which national members will publish, for instance, open vacancies to identify them, or to interpret the very same criteria that are written in the statutes, in the treaties, or in the qualification rules that are foreseen. So the two panels are progressively influencing the national selection process by de facto harmonizing not only the criteria candidates might satisfy, but the overall transparency of the process. The harmonization is happening upstream during the selection process at the national level, but also downstream when the appointment authority is completing the process, sometimes through a negative opinion. A negative opinion is nothing else but a little return letter by saying you can do better. Come up with better names. Try to ensure gender balance. Try to come up with a more diverse process through which we can invite people to the cuisine, to the kitchen. Thus, for instance, both panels today seem to encourage member states to publish open calls for applications, something that many countries, notably in Central European Europe, have been doing, whereas some Western countries continue to refuse without any particular motivation or reason. But paradoxically, neither of the two panels are operating with the same transparency they are preaching vis-à-vis their national entities. That's interesting, right? You preach something you not abide by yourself. There should be good reason for that, and we're going to be focusing a bit more on those reasons. The dissemination of the panel opinions is extremely limited. When it comes to the EU, is the governments of the EU member states who receive it. When it comes to the Council of Europe, is only the individual government which is concerned. But the overall image that I would like you to keep in mind is that of a black box. We know who are the candidates who have been put forward, several in the case of the Council of Europe, just one in the case of the European courts, and then we know nothing during a few months, and then something is going to pop out. So we know the input, we know the output, but we know nothing what is in between. This is the black box we have. And we're going to be focusing on the black box in order to understand whether that black box, which is the kitchen, should be lightened up or should remain a black box. The principle of confidentiality is the major reason why both bodies are refusing to disclose any information stemming from their own work. They argue that any departure from this might unavoidably compromising their own operation. But my claim, you won't be surprised, and I believe to have heard something similar from my fellow panelists, is that given the profound transformative effects that those panels are having on European Court judicial selection, their current restrictive policy of transparency does seem to raise some important and unaddressed question of democratic legitimacy and accountability that cannot be dismissed by saying, where do we end in terms of going upstream and redefining it? Those issues are there. This is a black box which is raising concern. Neither panel is subject to any form of democratic oversight, and there's a very important link that is very often overlooked, that it has not been mentioned today, in the way in which those members sitting in those oversight bodies have been identified and selected. And is the link between the president of both courts and the selection process of them. This has been defined in the literature as a germ of a council of judiciary within the union. So the link between the actual court members and the future courts through the selection body is something that has also been to taken into account when judging about the transparency of his own operation. Up until now, there was no way the actual courts members could have been shaping the future court members. Now there is, and this link has been institutionalized. And it is against this backdrop that one might wonder whether the confidentiality policy today is actually justifiable or is rather problematic from an accountability perspective. While one may intuitively understand the need for discretion, the panel current transparency policy seems to question the legitimacy of the panel itself. And sometimes we wonder whether the panels want to protect the candidate's reputation or privacy, or whether they want to protect their own operation from outside scrutiny. This is so because despite their mere advisory role, the panels are listened, carefully listened. We are not aware of any instance in which the panel assessment has not been shaping the final decision of appointment. In the case of the election, it's more complicated because we have more than one candidate that actually make it and is going to be presented to the assembly for vote. So let me come to my research question. What is the optimal level of disclosure, assuming there is one? 4 major arguments have been invoked against, and they've been mentioned today. The duty of confidentiality in order to not to curtail the operation of the body itself, which is making this assessment. Data protection, the sensitive data that are contained into the assessment itself. Reputation, and the potential chilling effect on future candidates. If you're going to be too strict, nobody is going to be there, especially if everybody will have access to the evaluation. How can that particular candidate would find a job afterwards? Both panels do seem to be in line when arguing or putting forward those particular elements in the public discourse. My overall argument in relation to those 4 justifications is that the full publicity of the process, meaning being able to understand more about how these bodies work, and in particular, what kind of process, what is going to happen in the black box, might actually strengthen the authority of the European Court and the entire European judicial selection process for the very same reason that were mentioned earlier by the panelists. I also believe that this might meet the general public expectation and probably the zeitgeist. So let me focus on the major argument invoked so far by both panels to oppose public access to their output. And this argument is the reputational one. Reputation pro futuro. We want to make sure that the integrity of the candidate will not be put at stake, not to deter them to become judge or to dream of becoming judges one particular day, and to possibly remain in the professional world and not to be damaged by that decision. But the argument here is that the current confidentiality policy does not only fall short of protecting the candidate's reputation, but is actually threatening it. Why? Because of speculation. In this room, we belong to an epistemic community in which we know very well what's been the name which has been put forward before the black box, and we also know whether that name has been confirmed, it has not been confirmed. The pure absence of information around it will give rise, and it will be gossip-inducive. There might be good reasons why that particular candidate didn't make it that should be disclosed, that will never be disclosed, and they will be part of a broader conversation that is going to happen in the corridor, meaning it's going to stay in the kitchen and perhaps in a few corridors surrounding the kitchen rather than being disclosed. The very same annual reports that have been drafted over the years seem to suggest that the non-confirmation of a particular candidate does not automatically suggest that something went wrong. There might be many other reasons. There might even be a withdrawal that it might occur at some particular point. But we will never know. We will never know about this because it remains a black box. So the final point here is that if the public is aware of the reasons that a judge was appointed or not, disclosing the opinion of the panels would actually increase the perception of personal integrity of the judge, and as a result, the jurisdiction will potentially benefit from it. The possible solutions for balancing with a bit more nuance in light of the power acquired by those bodies, the privacy, and in particular the more personal reasons of the individual and the public interest expectations are multiple. One possibility, in order to become more socially ready to accept this, might be to disclose the opinions of those candidates who actually have become judges. So it would seem very difficult to imagine a situation in which those candidates would be against, or the very same court would refuse to disclose the successful evaluation that has led a particular candidate to have positive. The pedagogical function of the body would also be increased, so the member states will learn certainly better about what candidates should be put forward, and therefore we might, over time, accept and enhance the pedagogical role. We could also maximize the pedagogical role for some forms of pre-pressure and some forms of name and shaming vis-à-vis those countries who are still not, for instance, whitening up their national procedures. So we still have countries who refuse that particular format. Overall, I believe that transparency might be the better instrument to make sure that the transformational effect that those bodies are having in the judicial process will be recognized by the public by aligning the expectation of the public with the daily operation of those courts, and therefore increasing acceptance of their own decisions. Thank you.
Thank you. Thank you very much. Thomas, do you want comment the comments?
Just very briefly, I would actually like to ask you a question. You spoke of the obstacle course you were going through, and I can imagine it's an obstacle course. Would it have been too much of an obstacle to go through a public hearing in the parliamentary committee? Would that have made a difference for you? And would then you have been inclined rather to withdraw your candidacy than to go through that? Or would you think that candidates for judgeship in Strasbourg should manage such an open process? That is one question I have. And yeah, perhaps that is my question to you. And concerning Professor Alemanno, I also think that the panel procedure should become more transparent. The question is, how much to disclose without harming the reputation of anyone. But I mean, I wonder if I imagine I was a candidate. If I wouldn't be relatively sure to be confirmed, I wouldn't stand as a candidate in such a process. And would that really, I mean, if I think I'm not able to perform the function of this or that office, I wouldn't try to stand as a candidate. And would that really deter suitable candidates from going through the confirmation process, or is that just a false argument by those who want to protect their own dealings and their own power over the process? Perhaps that's all I want to say on that.
I'll try actually to answer both points and at the same time clarify one or two differences between the Strasbourg selection procedure and the Luxembourg one, and Alberto was primarily addressing the Luxembourg one. The obstacle course. First of all, I knew it would be an obstacle course. It didn't deter me. And I entirely agree with you that this argument that people will be deterred if they think that they mightn't be successful, I think it's a false premise. You have to have a certain degree of personal and judicial mettle to go into one of these courts and to deliberate in the circumstances that we do. You engage in a form of polite judicial combat every single week. So going through an obstacle course on your way there, for me, was perfectly acceptable, normal. A parliamentary hearing, which is public, it would have given me serious pause for thought. And I don't know whether I would have proceeded, for the simple reason that the next day you go back to the day job. Or if you are successful, a few weeks later, you will be sitting in a case which may touch on a subject on which you've been questioned. And yes, I see your reaction, but we can sit and watch the Senate hearings for US Supreme Court candidates, and we can see them duck and dive. And remember, they've gone through an extraordinary process of preparation provided by the authority which has nominated them. No Strasbourg candidate has that, nor should they. And you risk also having the court which then houses this judge who's been subject to this questioning. And remember the type of questions one could receive. And you're being questioned by politicians. And there are pending cases. And some of them are interstate cases. The court will then have to deal with requests for the judge to recuse themselves. Now, I work in a court with approximately at the moment, and this is actually a success story, although it won't sound like it when I give you the figure, 52,000 pending applications. We have very little resources. We don't have enough judicial assistance. We have a lot of pressure on our backs. Parliamentary hearings, it's a beautiful idea, but I'm not sure that that's where the real problem lies. So I've tried, therefore, to answer your first question, and indeed your second, about this idea of, well, if I'm not successful, then I won't apply. I agree with you entirely. Everyone applies for a post, whether it's judicial or otherwise. Considering, am I a good candidate? I think I'm a good candidate. I may not succeed. We all do that throughout our entire professional lives. An important clarification on the distinction between the Strasbourg procedure and the Luxembourg procedure. Strasbourg, as you know, there are 3 candidates. And I think Alberto is right. The crucial decision is at the national level, because it is quite simple. If you put forward 3 very good candidates that you are happy to have sitting in Strasbourg discussing either, let's think of recent cases, Ibrahim against the United Kingdom, the right of access to a lawyer of a terrorist suspect, or Kleifia on collective expulsion in the immigration and asylum crisis in the Mediterranean, or ABC against Ireland on the failure to legislate for abortion following a previous Constitutional Court decision. If you think about the cases that these people are going to have to deal with, and you put forward 3 names that you are happy to see any one of them come out the other end, well, a good candidate will come out the other end. So the national selection procedure is absolutely vital. In Strasbourg, the advisory panel has been placed there in quite a different position to the 255, because the advisory panel talks to the national selecting committee and says, we have concerns about 1 or all or 2 of your candidates. And they then can withdraw the list and submit another list or make adjustments or provide further information. The advisory opinion of the Strasbourg panel does go forward to the Parliamentary Assembly and, crucially, to the committee which interviews the candidates. But it isn't binding in the same way that the 255 isn't binding, but it's even less binding. I think that can safely be said. And the former Chief Justice of Ireland, John Murray, who was the president of that advisory panel, has indeed argued, and I think for legitimate reasons, that the advisory panel's opinion be given more weight than it has been given in some circumstances. Then what happens on the obstacle course? You're called to an interview, and you're interviewed for 30 to 45 minutes by a panel of 20 to 25 people. And then they give an opinion which goes forward to the PACE, the Parliamentary Assembly Committee. Now, if we want to talk about transparency, it really is quite transparent, all things considered. It's not a public interview. It's not a public hearing. However, what happens is that from that moment, the CVs of all 3 candidates are on the internet. You can look them up and consult them, and I imagine they're still there. The national selection procedure is described in detail, and then the panel gives its opinion. It doesn't give a detailed account of their discussion, but it has a way of indicating very clearly its position, because its code is quite simple. Unanimously, by an overwhelming majority, by a majority, or they say these candidates are of equal value, and then it goes on to the PACE. And it's true that what happens in the PACE is not known to us, but that's because the vote is a secret ballot. And a secret ballot is a secret ballot. What happens prior to the secret ballot, it's true, we don't know. So it's an imperfect system, but to explain to you the degree of transparency, I went to the Paris interview. I left, I heard nothing more, until I was sitting in my kitchen, having a cup of coffee one Sunday morning, and I received an email from a PhD student in Copenhagen, who happens to be Irish, who'd met me at a conference, and who said, congratulations. And I said, why? And he said, because you've been nominated by the panel, the interview panel, by an overwhelming majority. Now, for me, that was very pleasant news, having my coffee. For the 2 candidates who I knew, who were informed in the same way by someone in their law faculty or in their, wherever they were, I don't think that it was so pleasant. I would have liked for the procedure to have been transparent in the sense that the candidates were informed before the information was on the internet. But we weren't informed. You put up with the wounds that the obstacle course inflicts on you, but you can perhaps make recommendations as to its improvement. I hope I've answered a little bit of your questions. In brief, I wouldn't personally see the need for a public parliamentary hearing. I think that the systems could be improved without going that far.
If I may, very briefly, on public hearings, I agree with most what has been said so far by Siofra. I think culturally we are not ready for it. I don't see more advantages than disadvantages in introducing it, so it's probably not worth it. But I think we all agree from this conversation that the times are ripe for ensuring more disclosure, more transparency surrounding the overall selection process, which does not exhaust itself in the black box, but it starts very early in the process. So one of the most positive effects of the oversight bodies has been to create this spillover effect and this pressure on the member states. So we don't have to forget here, we're not focusing only on the candidates, we're focusing on the member states who are the generator of the whole selection process. So to what extent disclosure might actually help us achieve our policy objective, which is to increase the quality of the candidates? This is the question. And I think if this is the question, transparency can be a tool for it, and it's not public hearing that are going to address that. But certainly providing more information and putting pressure and name and shaming for a negative opinion on a candidate that is coming out of a process which is politicized, which is still has something to do with an old boy network like in the old days, should not exist anymore. And unfortunately, confidentiality today is also making this possible in a way. Is somehow making the whole process a bit suspicious, or to look suspicious, and also to fail to protect certain candidates. Because one issue we haven't discussed today, and it represents a bit of an answer to some aspects that Siofra mentioned, is that the candidate today, being alone in that kitchen with not much light, he might be questioned about his own position, his own previous writings in relation to a case law he didn't or she didn't have the chance to shape. It might be someone who believes in the horizontal effect of directives, and well, the person sitting in the panel, they disagree because they've been part of a different kind of case law. We don't have any form of protection for the candidate there. It won't be possible for anyone to say, I got a negative opinion because I disagree with half of the people who are in the panel. And today, this kind of polarization may also exist among public scholars and legal scholars. I'm not going as far as in the US, but certainly not a public figure will fix that, but rather disclosure or what kind of conversation, of kind of questions, because you push me to think about what kind of policy solution we can imagine. And I think we can be very creative and very nuanced. We don't have to disclose the overall text, but I would like to know what kind of questions have been asked, because we don't know the nature of the conversation which is happening between the body and the candidates.
Yeah, thank you very much. We have a short time. Herr Kirchhoff, hatte ich, ne? Noch nicht. Yeah.
I'm Costas Popatos. I work for the Court of Justice. I worked in several positions. But I was intrigued by the very last word of Alberto's first presentation. He referred, if I'm not mistaken, to the accountability of judges to the general public. So if I understand that well, I think we are in front of a maturity problem. Reality is, the question is, what is the use of fitting the kitchen with windows giving sight to the external world? So here's my test. If the concern is about the general public, would you trust a referendum to select the judges? And do you believe the public would be mature enough to know, or would be concerned about who is elected as a judge at the Court of Justice or in Strasbourg? Thank you.
Thank you. I think the metaphor has its own limits. First of all, the kitchen is not in the court because the judicial process is in the hands of the member states. But certainly, what we are discussing today is not questioning who is appointing the judges. I don't think we are questioning the counter-majoritarian nature of the court. We're simply considering that in the process of appointing, making sure that citizens who are qualified to become judges, that process can be partly more open and more understandable to the outside public. The more understandable it will be, the easier and likely will be the acceptance of decisions taken by those individuals and affecting the lives of the many. I'm not arguing more than that.
I think my point is actually just confirming that. First of all, say that I think that the public is, to a certain extent, interested in who gets appointed as judges. There is a democratic deficit because they are appointed and not elected. Having been involved in judicial appointments processes, I can say absolutely that I think that transparency is essential, as much transparency as possible, but I also recognise that there is a price to pay. And I do believe that there are people who are well qualified and who probably would make very good judges, who for their own reasons will not go through the process because of lack of confidentiality. And even even though in the English judicial process, judicial appointments process, we don't publicise the names of the candidates, they are very often known, and of course, because they have to have referees, their friends, their network know that they are candidates. And there are some, I'm not saying it's right, but I'm saying that there is a price to pay and that you will lose some candidates. But I think it's a price you have to pay because you have to have transparency. You have to have that confidence in the appointment process. And I also agree that the transparency isn't the end, that what we're looking for is competent judges who we trust.
No, I agree.
So do I.
I have a short question. We have compared 4 selection processes. Some are domestic, others are transnational, international. Does it make a difference to have a national process or an international one? I also heard a little bit about educating member states to present the right candidates. Isn't that also a little bit dangerous to go in such a direction? So it might be that it is understood in a different way, and there might also be a tension at that supranational level. Just a question. I would like to have your reaction on that.
Shall I start? If you have an international selection process, you always have a dual process, because usually you have a national candidate. So there must be a national selection process that precedes the international process. And as I tried to explain, we do have, and Professor Alemanno supported me on that, you do have repercussions of the international process on the national selection process of candidates, including transparency. If you have a process which involves 28 member states, like in the EU, or even 47, like in the Council of Europe, the different legal and political cultures of the member states have to be taken into consideration, I think. And if you have an international process and consider the transparency, you have to take into consideration that transparency may be more important in member state X and Y than in member state A and B, and you will probably have to have a compromise, because a process which is acceptable in member state X wouldn't be acceptable in member state A, and that may even be counterproductive in generating public confidence in member state A on that court composed after such process. So that is certainly something to take into consideration.
Yeah, thank you very much.
May I quickly address the second part of the question, which I think is very interesting, about the fact that these oversight bodies were created to exercise this pedagogical function. So they assess the suitability in concrete of the candidates, but while doing so, they also exercise a suitability in abstracto, meaning they are redefining, or they are reading again the criteria and redefining the process. In an international context, the rationale is to somehow harmonize the way in which the candidates are selected. It's not necessarily changing the culture, the Germans selecting certain candidates or the French selecting other kind of candidates, but on the longer term is producing such a transformational effect, is inevitable, is part of the conversation, and is part of the policy goal. This might, in the long term, from a cultural perspective, also change the dynamic and the composition of the court. And this is something overlooked, largely understudied, but I think it would be very interesting to see what is happening since the institution of this. So trying to trace back the indirect consequences of these bodies in the selection process that is happening at the national level.
I will very briefly only address the first part, because the second part I think was directed more at Alberto. Is there a distinction between national and international? I think the same skill set is required to be a judge at either level. I think perhaps certain additional skills may be required at international level because of the way in which those courts function. A good judge at national level is likely to be a good judge at international level. But what the both advisory panels have in their composition are judges who've done the international job. Is that a bad thing? I don't think it is. They know what it's about. They know what's required. There are, as the speaker has indicated, no separate opinions at the Court of Justice. That means you have to work in a collegiate body trying to work to a majority decision and feeding constructively into that process. There are separate opinions in the Strasbourg system, but in my personal opinion, they should be used sparingly and to good effect, rather than excessively and perhaps to less good effect. So I think there are enormous similarities. Before the court was made a permanent court, the Irish judge for many, many years was Brian Walsh, a Supreme Court judge in Ireland. Those judges came to Strasbourg occasionally and sat on. The court is a different body now, but we do the same job. I'm a very different judicial animal to Brian Walsh because I've followed a European path. We bring different skills to the job, but hopefully we both exercise the judicial function with the same end in mind.
Yeah, the time is out. And I'd like to thank the speaker and discussants from the audience. We have 20 minutes, a coffee break. Well, now let us have a coffee break.